My name is Jim Musgrave. I'm past president of ADRIC and delighted to be the room host, and would take the opportunity to introduce our speakers for the afternoon. Daryl Willits is the leader of dispute resolution development with Alberta Justice and Solicitor General. In this role, Daryl is responsible for the development and standards of the ministry's dispute resolution programs across Alberta, which includes civil mediation, family mediation, child protection and intervention, brief conflict intervention, dispute resolution, and child support resolution officer programs. Prior to his current role, Daryl was a conflict management trainer and practitioner with the Department of National Defence, working as a private consultant specializing in workplace conflict resolution in Canada and the United States, and served in Bosnia and Afghanistan as a member of the Princess Patricia's Canadian Light Infantry. And Gina Alexander is currently the Executive Assistant to the Deputy Minister to the Premier for the Government of Saskatchewan. In her previous position, Ms. Alexander was the Assistant Director of the Dispute Resolution Office with the Saskatchewan Ministry of Justice. In that role, she was responsible for the delivery of province-wide programs, including court-annexed mediation, fee-for-service mediation, and training. She's been active in the dispute resolution field since 1997, and has also served as dispute ombudsman with the Ombudsman Saskatchewan's office. Patricia Elliott is a policy analyst with the Family Justice Service Division, BC Ministry of Justice. She has recently been involved in the exploration and policy development of the notion of mandatory consensual dispute resolution in family law in BC. Prior to her current role, she was employed by the Employment Standards Branch, Ministry of Labour, as an industrial relations officer and team lead, where she conducted adjudication hearings, investigated Labour Relations Board certification applications, and conducted industrial relations investigations. Loretta Richens was responsible for setting up the provincial court civil mediation programs throughout the province of Alberta, including the provincial court civil mediation program in Calgary, where she managed the daily operations. She's been with Alberta Justice for 6 years, and prior to that worked on contract for Alberta Justice through the Better Business Bureau of Southern Saskatchewan.
Alberta.
Oh, sorry, too many S's. I love alliteration. The Better Business Bureau of Southern Alberta. In May 2014, she took on a new role with Alberta Justice as leader dispute resolution delivery, a role in which she oversees the delivery of the branch's dispute resolution programs and is accountable for operational planning, performance monitoring, and reporting. And Michael Williams was called to the bar in Manitoba in 1989 after graduating with his law degree from the University of Manitoba, and has been immersed in family law since then. The first 16 years of his career were spent in private practice with a specific focus on First Nations child protection. He left private practice in 2005 to join Manitoba Justice as the Senior Support Determination Officer of the Child Support Recalculation Service. He has written and presented papers on various topics in family law through the Law Society of Manitoba and the Manitoba Bar Association. He was involved in the MBA Family Law Subsection Executive for close to a decade and ultimately served as chair of that section. His community involvement includes participation as a board member of Adoption Options Manitoba, Inc. Ladies and gentlemen, an impressive array of speaking for this afternoon. I'll turn the table over to Daryl. Thank you.
Thank you. Welcome, everybody. I can't say enough how much of a privilege it is actually for me to have had the opportunity to work with these panel members from different provinces and for us to get together and share information. And so really the intent of this session today is for us to share with you some of the information or some of the steps that we've taken to work more collaboratively together as the Western provinces to advance ADR in general, and specifically as it relates to court-connected ADR and mediation programs. And also to share information specific to each of the court-connected ADR programs from Alberta, British Columbia, Saskatchewan, and Manitoba, and to allow you the opportunity to ask questions of us about those programs and to make suggestions for how we as the Western provinces can work better to promote ADR going forward. So this is really a unique opportunity, and I've been so excited to work with these other panel members. I'm excited to be here today and to share some of the things that we've done. And I'm excited to be learning how to use WebEx and to bring it to the next slide. Patricia, can I get some help, please, going to the next slide? Okay. I apologize. Patricia, if you can hear me, can you control to the next slide, please? So I actually don't have the ability to control the slideshow right now, and it seems like... Michael, can you hear me? Because I can see you. Okay. So you know, this was working perfect earlier, and I was actually about to start talking about how awesome WebEx is. This is my first experience with it, and quite honestly, we were in here, we had it set up well, it was running perfectly. We'll figure it out. We'll get back to this, but I'm going to move on. And so really, the purpose of our task group is collaboration. We're looking at collaborating. We're looking at sharing information specific to each provincial program. And really we're looking at sharing information specific to qualifications, we're looking at sharing information to program delivery, absolutely everything that you can think of related to alternative dispute resolution programs and court-connected alternative dispute resolution programs we're discussing. And this is exciting because for, basically as far back as I can tell, I don't know when this has been done before at this level, where provinces have gotten together and really started to collaborate at this level to promote ADR, and specifically to promote and identify some of the shared challenges and lessons learned through delivering different programs as well. So the purpose of our task group initially was for collaboration. So Patricia, I can see you. Are you able to help me advance the next slide? All right. Oh, okay. Excellent. And then the one after, please. Thank you. We're back on track. So again, the purpose of our task group is collaboration. It's to learn. We're looking at learning from each province's experience. We're sharing best practices. So really, we've identified challenges, gaps, risks, and we're looking at how we can better work together to support ADR as a recognized and viable option for the resolution of disputes. And so this goes all over different areas. Next slide, please. Perfect. So one of the things that we started doing is we started identifying emerging trends and policy issues. So a couple of the things that we've started discussing, and what we hope to receive feedback from you and any of your colleagues, is how can the Western provinces work collaboratively to advance ADR? How can we promote mediation as an acceptable and widely recognized part of the justice system, as opposed to simply being mandatory or an alternative? We really are helping to advance, or we're looking to help advance that cultural shift, where people look at ADR mediation programs not necessarily as mandatory alternative, but just something that you do when you have certain types of legal issues or challenges, and rather than engaging the court system directly. We're also looking at how we can promote consistency among our provincial programs, and that relates everything to fees, to how programs are accessed, to service provider qualifications and standards. It's really, again, something that's exciting for us to be able to do, and I think that those in the room who have experience with different programs note also that there's a tremendous gap between how certain programs are delivered, qualification standards, and that relates to a lot of the work that ADR Canada is doing as well in terms of the professional designations. And so if we can bring ourselves better aligned with that as well, and some of the other organizations that are promoting standards, then I think overall ADR will be better, and that's how we can help. So with that said, I think, can we go to the next slide, please? So we just have the other remaining policy and emerging trends that we're looking at is how we can better assess and determine appropriate dispute resolution or responses to dispute resolution. And this relates, I think, those who attended maybe the Reforming Family Justice Services talk, and there's all kinds of other initiatives, both within government and outside of government, that are tailored specifically at looking at how we can better assess. What are the ways to properly identify the most appropriate resolution track for specific Alberta, or for specific clients or people engaging government systems? How can we better evaluate the effectiveness of ADR programs? This is critical, especially when we're talking about government programs. The reality is everything works off of numbers. We need data to be able to demonstrate the value of something, to get funding in order to continue it, to provide additional services and expand. So the learning and the exchange of information is helping us do this as well. We're also looking at how we can develop a system to capitalize on our learning. So how can we continue this going forward? When us as panel members are no longer involved in this project and other people are in our roles, how can this continue? And one of the very positive things is this is supported at our ADM, our deputy minister level. So this entire project wasn't something initially that we got together and decided on our own that we wanted to do. This was a recommendation from a deputy minister's Western Conference. And so we do have support for this. And really we're looking at how we can continue communication, make it standard practice to meet regularly, communicate, share information, and learn from each other. So with that said, I'm going to share at the end some of the guiding principles that we've discussed, but part of the learning for me was being able to see what's going on in the other provinces. What programs are offered? How are they accessed? And that's what we'll go to now. So we'll be able to hear from British Columbia, and we have Patricia.
Hi everyone, can everyone hear me?
Yes.
Great. So I'm going to talk a bit about our court-connected mediation programs in British Columbia. So firstly, we have our family mediation program. We have both the voluntary program and then we have a mandatory information and assessment program called Rule 5. I'll speak a bit about our child protection mediation program, the civil notice to mediate that's used in Supreme Court here, as well as the small claims mediation program. That program is currently being phased out in favor of the new Civil Resolution Tribunal, which will be coming into effect soon. And then I'm going to talk a little bit about mandatory consensual dispute resolution, which is something that we're also exploring. So in terms of family justice mediation, we have 67 family justice counselors that are employed by the Ministry of Justice to assist clients with all range of disputes regarding guardianship, parenting, contact, and support issues. All of those family justice counselors are mediators certified through Family Mediation Canada. These family justice counselors, or FJCs as we call them, also provide information and education to clients regarding the court system and other resources. Sorry about that. So eligibility criteria for the voluntary program is wide open. It is a voluntary program. About 70% of our clients are families of modest means, but the services are accessible to anyone free of charge. The only criteria really has to do with the issues that are being mediated. So any issues to do with the child, so connected with the child parenting issues and or support issues are covered. They don't cover property related issues. Rule 5, so under the provincial court family rules in British Columbia, litigants in 4 separate locations, so 4 of the larger registries in the province, Vancouver, Kelowna, Nanaimo, and Surrey, are required to see a family justice counselor after they have filed an application in court, prior to having a court appearance scheduled for them. So when those litigants go to see a family justice counselor, they're provided with information, options for dispute resolution, assistance with court forms as well. The family justice counselor assesses the party and the family and determines if mediation is going to be an option for them, and then they can voluntarily engage in mediation. They can pursue their court case, or they can do both. That's how Rule 5 works. So some stats on family mediation. In 2014, there were approximately 3,200 clients who were referred to those mandatory Rule 5 services. Of those, about 2,000 of them participated in the mandatory intake assessments, and there's a consistently about a 70% success rate with mediation, with all or some issues being resolved. Currently, we are evaluating the Rule 5 program. The Rule 5 program has been in place for 17 years. Last evaluation was done in 2002. So there is an evaluation underway right now to see if there's things that we can improve or change with that program. With respect to child protection mediation, that program's been in place since 1997 and supported by the CFCSA, which is the legislation that governs child protection in BC. So the social worker or the family can choose mediation by contacting a mediator. It's a process for working out disagreements in child welfare related to the plan of care for the child. There's been a real spike in volume in the last 10 years with child protection mediation, about 250%. So eligibility for the child protection mediation program it's available throughout the life of a file, so from the pre-removal stage to permanency planning stage. So anytime during a CSA file, it can be referred to mediation. It's not limited to contested court applications, so it could be for parties who are working outside of court. It's voluntary and confidential. There is policy direction that there is an obligation on behalf of the social worker to consider mediation. In 2014, 2015, we had about 7,400 people involved in mediation services under child protection mediation. There was an average of about 8 people per mediation. And there's a very high settlement rate there for some or all issues, about 96%, 62% where all issues were resolved. So I'm also going to talk about the notice to mediate. So this is a process that enables a party in an action in BC Supreme Court to compel all other parties to the action to mediate the matters that are in dispute. Notice can be used at any time between 60 days after the filing of the first statement of defense and 120 days before the date of trial. So there's a span in which the notice to mediate can be used. Certain types of cases are exempted from the process. A large number of those cases that do go through the notice to mediate process are motor vehicle cases. So parties jointly agree on the mediator. Mediation must occur within 60 days after the mediator's appointment, but no later than 7 days before the trial. If a party fails to comply with the provision of the notice to mediate, any of the parties may make application to the court for a default order. If this occurs, the court can order a pre-mediation conference, order a mediation session, order that a party attend either of those conferences or sessions, can stay the action until those obligations are met, or order anything it considers appropriate with respect to costs. So the cost of the mediation is borne equally by the parties unless the parties agree to some other cost-sharing arrangement. The process only mandates that the parties attend mediation and are not required to reach a settlement, just that they attend. So some statistics. So really what we track in terms of notice to mediate are the motor vehicle personal injury actions. And so that's been in place in BC for 11 years. And over the last 11 years, there have been 23,000 mediations held with a settlement rate of about 80%. So small claims mediation. So in Vancouver, previously, we're in a bit of an odd situation in BC now with respect to the small claims mediation overview because some of these programs are being phased out. This is how they were occurring right up until very recently. So in Vancouver, most claims above 5,000 and up to 25,000 and all personal injury claims are mandated to go through the free mediation session under Rule 7.4 of the small claims rules. In Surrey, North Van, and I'm in Victoria, you were required to attend mediation for claims below $10,000. Mediations were held for 2 hours and they were conducted by private mediators who were assigned via a roster through Mediate BC. And cases that were unresolved in mediation were set down for a judicial case conference. So criteria for small claims, again, in Vancouver, it was really down to numbers. More than 5,000, less than 25, and in the other 4 registries, less than 10. There were exemptions for cases where there were restraining orders or peace bonds in place, and there were some other administrative exemptions as well. There was no income threshold to qualify for those services. So with small claims mandatory mediation, all named parties needed to attend the mediation unless they've been exempted from the process by a judge. And when the parties attended mediation, their presence and participation becomes voluntary after the completion of the first phase of the process. Agreements were documented by the mediator, filing the result of mediation at the registry, and the parties preparing and signing the mediation agreement, which was then filed and enforced through the court. So that's how the administrative process of the documents worked. So between 2011 and 2015, there were about 6,100 cases referred to mediation. Of those, about 4,200 cases were mediated under 7.2 and 7.4, so in all of those registries. There was about a 50% resolution rate, and small claims mediation program is now being phased out with the advent of the Civil Resolution Tribunal. So I'll talk a bit about what the new role of the Civil Resolution Tribunal will be with respect to small claims. So the Civil Resolution Tribunal Act was passed in 2012 and then was amended again in 2015. So initially it will be voluntary. So using this method of resolution will be voluntary for most condo disputes as well as all small claims matters. After the first year, it will be mandatory for most condo claims and small claims matters under $10,000. So how the process works, it's an entirely online platform, and it provides litigants with information, allows them to diagnose what their issues are, and it helps with assisting on calculations if they're trying to work out what their claim might be. Parties then have the option to negotiate with each other using an online negotiation tool that's just party to party. If that is unsuccessful, then they can get the help from a case manager, who are able to facilitate a discussion and provide a neutral evaluation of the case. If there is no resolution at that point, then they can ask the tribunal for a binding decision. So this is an illustration of how this would all work. So assuming that the volume will go down as we get further towards adjudication, but starting with information, problem solving, going to party-party negotiation, and then to case management, and then adjudication. And you can see from these icons at the bottom, so sometimes you'll be on the computers and then you'll have help by phone. Other times there's the ability to have face-to-face facilitated negotiation and adjudication. So again, the initial launch will be voluntary and it will move to mandatory in the future. There is a desired expansion with the CRT to include other civil court issues and administrative tribunals that we haven't gotten there yet. And the last thing I wanted to talk about today is mandatory consensual dispute resolution. So right now, the Family Justice Services Division is exploring the concept of mandatory consensual dispute resolution, which is a mouthful, in the family justice system. The concept really involves the integration of the information assessment and ADR phase of what we do in family justice, dovetailing with the more traditional court system. So how it would work, clients would mandatorily attend an information and assessment triage. Clients who are assessed as being appropriate for mediation or other types of ADR would then be streamed into a dispute resolution stream and would mandatorily be required to attend at least 1 or 2 mediation sessions. Clients who were assessed as being inappropriate for mediation, so those people who were maybe experiencing family violence or if there was imbalance of power or other reasons, would be streamed into the court process. So the whole thing would be triggered by filing an application in court, and there would be an opportunity for parties to get interim orders from the court pending the outcome of the mediation stream, where urgent orders were needed, or if one party was refusing to participate. So that is BC. And Daryl, I think we'll hand it back over to you. This is my contact information if you have any questions. I think we'll all be available at the end to answer any questions that you might have as well.
Thank you.
So I guess I'll begin about the Alberta programs. So Alberta Justice has 5 ADR programs: Provincial Court Civil Mediation, Child Support Dispute Resolution Officer Program, Family Mediation, Child Protection and Intervention Mediation, and Brief Conflict Intervention. So I'll begin speaking a bit about Provincial Court Mediation Program. Provincial Court is more commonly known, of course, as Small Claims Court, and the types of claims that are dealt with are debt and damage. In Alberta, the financial jurisdiction is $50,000. The name small claims is becoming a little bit of a misnomer. All disputed claims are actually reviewed by a mediation coordinator, and it's determined at that point whether or not they feel that the file is suitable for mediation. And they base that on the pleadings. And throughout the province, 60% of those files are diverted into the mediation program. The type of mediation used is non-evaluative, facilitative mediation, where the mediator facilitates the discussion, and the decision and the outcomes are made by the parties. The services of the program are actually delivered by 220 roster mediators who are located across Alberta. The mediators are required to meet certain qualifications and standards that the program sets out. And to give an example in terms of numbers, in the fiscal year 2014-15, there were 2,337 mediations conducted, and out of those, 56% were fully resolved at the table. And typically those mediations are between 2 and 3 hours in length. And so there's a 56% resolution rate, and there was actually an 85% satisfaction rate. So we find that interesting in that tells us whether a matter resolves is irrelevant to the client really appreciating the service in most instances anyway. The other program I'd like to speak about is a dispute resolution, child support resolution officer programs. And so these programs actually are very similar. The dispute resolution officer program is located in Calgary, while the child support resolution program is located in Edmonton. But the purpose of both these programs is to help litigants resolve their child support issues. These program services are delivered by a roster of 100 experienced family lawyers who practice evaluative mediation. The parties meet for 1 hour with a DRO or CSR officer who will discuss the matter with the parties, describe the requirements of the child support guidelines, and help the parties resolve their dispute. And in 2014-15, 2,000 sessions were conducted in those 2 cities. There is no income threshold for the dispute resolution child support programs. The criteria is a little bit different. In Calgary, with the DRO program, it is mandatory for all applications for child support matters in the Court of Queen's Bench, with the exception of provisional applications under the Divorce Act. And so the DRO program services clients after they've made an application at the Court of Queen's Bench. That said, DRO meetings are also available on a voluntary basis. The child support program in Edmonton, it's actually mandatory for self-represented litigants before they're able to make an application. So that's the key difference. And all self-represented parties who wish to file a child support application, with the exception of provisional orders under the Divorce Act, must attend a meeting before the application can be filed. Daryl.
So I get to speak to the Alberta Justice Family Mediation Program. This program is available at no cost to eligible parties, and what that means is to be eligible, at least one party must have an annual income of $40,000 or less. I see some facial expressions, and I think we realize that that number needs to be looked at more seriously going forward. There also must be at least one dependent child under the age of 18 or a child who is 18 years or over and eligible for continued child support based on educational or medical need. Mediators in this program practice non-evaluative facilitative mediation. And services are delivered by staff and roster members. So we have staff in Edmonton and Calgary who deliver these services, and we have 60 family mediators on roster who are located throughout the province. Our roster members are on contract. Both staff and roster members need to meet very similar, if not identical, qualification standards. And what that means is our roster members must have a degree, and our staff must have a degree in psychology, education, social science, like anything in the social sciences. So it could be social work, law. They must have 180 hours of conflict management training with at least 40 hours specific to family mediation, and a significant amount of experience. And so those who don't have experience, we do also offer some mentorship opportunities in order to join our program, but that's really what we're looking for. During the fiscal 2014-15 year, there was 1,413 mediations completed from our family mediation program with a resolution rate of 89% and a client satisfaction rate of 97%. So we also have a program called the Child Protection and Intervention Mediation Program. This program is very similar to the family mediation program and how it's delivered and the qualification standards, except that this was developed in response specifically to inclusion of ADR in the Child, Youth and Family Enhancement Act. And so this is a cross-ministry effort, so it involves Human Services, Alberta Children's Services, and Alberta Justice jointly deliver this program. And really the idea is to support decision-making and permanency for children, ideally at an earlier stage in the process. Participation is voluntary for families, and this program also it has a resolution rate of 87%. We also have what's called the Brief Conflict Intervention Program. This is a little bit different than our family mediation program in that the emphasis is on education. It's on helping parents better understand what the impact is on their children while they're going through separation or divorce. Up to 10 hours of solution-focused intervention is provided by a clinician. Again, all of our clinicians for this program are actually on roster, on contract throughout the province. They must have very similar education criteria as the family mediation program. The only difference is that we don't require the 180 hours of conflict management training specifically, because what we're looking for is that clinical perspective, that assistance to help educate parents and help come up with parenting plans if appropriate and move forward through the process. The end result could be improved communication, understanding on part of the parents involved. It's also, there's a report that is completed by the clinician. The report is available to the court. It does not provide recommendations. And for this program, services are provided by 50 clinicians located throughout the province. Parties are required to attempt mediation before accessing this service. So before a referral can be made specifically to brief conflict intervention, parties are encouraged to either attend our family mediation program services or to have attended family mediation or mediation services elsewhere. One party must have an annual income of $40,000 or less, and this service is available to Albertans with or without actions commenced in provincial court or court of Queen's Bench. So, if you have additional questions or would like more information on Alberta Justice Programs, you can contact Loretta or myself, and additional information is available on this link, which will be provided to everybody who comes afterward.
Good afternoon, everyone. It's good to be here. Gina Alexander with the Dispute Resolution Office from Saskatchewan. Daryl and I and a couple of Michael envisioned the possibility of being part of this conference about a year ago. So it's great to be part of this group, and the only thing that would make it better is if I was there with you. So I'm regretting not having that opportunity. I'm going to talk about 4 of the programs that Saskatchewan has, although and I'm going to end off with just giving you a glimpse at the variety of programs that the Dispute Resolution Office has. We're just having some trouble with this with our slide, so just give us a minute there. I'm just going to carry on. The 4 programs that we have, sorry, Patricia, can you, there we go.
I can run your slides for you if you want, that's no problem.
Okay, there we go, perfect. All right, so the Queen's Bench Civil Mediation Program, the High Conflict Court Order Family Mediation Program, the Family Matters Program, and the Farmer Lender Program. Of those 3, the first one is a legislative program. The second one is a court-ordered program. The third one is, it is not mandatory, but I wanted to mention it in our slide deck today. And the last one, Farmer Lender Mediation Program, is also a legislative program as well. You could advance the slide. So just to start with Queen's Bench Mediation, civil mediation, the history of the program is that it began in 1994 in Regina and Swift Current. And every year we added a few more centers until 2008, where we swept the province and it became mandatory province-wide. The eligibility is that any party to a civil action must participate in the Queen's Bench Civil Mediation Program. There are 25 mediators. 20 of those mediators are contract mediators who are contracted with the Dispute Resolution Office, which is a government office. 5 of those mediators are staff mediators. So we have, as you can see, a combination of contract mediators and staff mediators. Our contract mediators are just that, available on an as-needed basis, not only in this program, but also in the other programs that the Dispute Resolution Office offers. In the Queen's Bench Civil Mediation Mandatory Program, 95% of the meetings are held in person and about 5% by video and or teleconference. And as you can see from the slides, there's a variety of types of civil suits that occur in Saskatchewan, similar to other provinces: contractual, personal injury, wrongful dismissal, medical issues, estate issues, products and services dispute. Thank you. The costs of the participants when they enter into a civil litigation in this province, as you can see, the plaintiff pays $200 and the defendant pays $100. That doesn't go directly to the Dispute Resolution Office. It goes to the province's general revenue fund. As you can also see, the average cost for a government file is about $600, and there's about 2 hours upfront work that the mediator does, typically with the lawyer. The lawyer is in advance of the mediation session, and the mediation session typically takes about 4 hours. And I'll just leave the rest of the stats for you to have a look at later. If you could advance it, thank you. So here's the structure of the program. At the close of pleadings, a mediation meeting is set. We don't require people to set a meeting. The only thing that we require is that they can't move on to another step in the process until they've held a mediation session. So the parties come to us purportedly ready to proceed, and there isn't a time limit. And just for context, because this will apply later when I talk about the stats, after the mediation, the next step is document disclosure, questioning or exams for people who might be more familiar with that language, and then there's pre-trial and then finally trial. Cases are assigned by a program manager, a program coordinator. They must attend, and if they don't attend, there are implications. And implications are such that they could be ordered back to mediation if they do not attend. They could be ordered to pay costs if they do not attend, and their pleadings could be struck if they don't attend either. You could advance. The qualifications of the mediators in most of our programs are the following: minimum of 100 hours of dispute resolution training, knowledge of the Queen's Bench court processes, shadowing for several files, and then a gradual shift to working as a sole practitioner. And in the Dispute Resolution Office, we have ongoing professional development training provided, not only as it relates to different kinds of files that we do here, but also as a group where we're getting together at least annually to do professional development. And as you can see, the mediator compensation there, contract mediators range from $35 to $55 an hour. For them at that rate, if some of, I can't see your faces, but I'm thinking there might be some surprise by that amount, that hourly rate. There isn't any overhead for the mediators. We assign the files. The files are held at the Dispute Resolution Office or at a location that the Dispute Resolution Office provides. So there's very little to no overhead for the mediators. And you might still be saying, but still, Gina, that's a really low rate. By comparison, our staff mediators range is about $38 to $48 an hour. So just so you know why we came up with that $35 to $55 an hour range. All right, so if you could advance it. Actually, if you could just move to the next slide, Patricia. So here, this gives us a picture of the typical resolution rates for the program. A third of the matters are resolved at the mediation meeting, which means that there's no further action. Another third might be partially resolved, but no further court action. So they're not going on for discoveries, they're not going on for document exchange. There actually is no further action involved there. And then another third proceed to further litigation, as you can see, document disclosure, questioning, and or pre-trial. So if you could advance the slide, thank you. The next program I wanted to talk about is our high conflict court-ordered family mediation program. The history, as you can see, it started in Saskatoon in 2008. We just a year ago started the program in Regina in 2014. The eligibility is that they must be court-ordered, and they're intended for parents who have multiple variations before the court and protracted conflict. That's it. We have about 6 mediators at any given time who have the qualifications and the experience to work in this area. And as you can see, it's delivered in person. We rarely do anything over the phone or by Skype or telephone, Skype or video conference here. And primarily the files are custody and access, parenting schedules, and division of property. The interesting thing about this program is that because of the high degree of conflict, because they're court ordered, and as you can imagine, they're not eager to come to court ordered family mediation. We're often working as co-facilitators or co-mediators, and typically we try and do a gender balance as well. You could just advance it. And then just keep going, Patricia, to the structure of the program. So high conflict court is held once a month, in Regina and Saskatoon. The files are identified by the court and then ordered here. Our mediators attend court when the matters are assigned, and then the mediator sets up time with the parties to participate in mediation. Some of the files last for 4 sessions. Some of the files, as you could see by the stats earlier, have been going on for quite some time, and that solely has to do with the nature of the program. And I'm just going to get you to click over to the next slide and then the next one. The judiciary and legal counsel of these clients are very supportive of this program. And I'm just going to point out the quantitative results here. We're showing a 62% resolution rate in 2014 and 2015. And I want to tell you, in 2010, I stood in front of the judiciary quite sheepishly saying, we're only at a 42% resolution rate 2 years into this program. And they actually applauded me. I was feeling sheepish about it. They actually applauded, thinking that's 42% of these files that aren't making their way through the court process. I'm over my time now, so I'm just going to leave it there. I just wanted to mention just one thing before I pass it on. You'll see in the slide deck the Family Matters program and then the Farmer Lender program. One note about the Family Matters program: it's in its infancy. It's been here for 1 year. We've had just about a year of this program under our belt. The purpose of the program is to interrupt the belief that separation and divorce has to be a fight. And we want to get to families early on. And once we get people settled down in this program, they're actually quite ready for prepared to do some problem solving. So I'll leave you with the rest just to read on your own. We're quite proud about not only this program, but the rest of our programs as well. I'll just leave the rest there because I'm over my time. Thanks, Patricia.
Hello, this is Michael Williams from Winnipeg, and I'm the Senior Support Determination Officer, Child Support Recalculation Service. We provide recalculations of table amounts of child support here. I'm not with our Family Conciliation Services or with the Justice Innovation, so I have a bit of a unique perspective on the group in terms of mediation issues. I was in private practice for many years, so I'm happy to see that in Manitoba we're able to do many things, perhaps without the formal requirements of mediation. What we do here in Manitoba is we provide services really in primary ways, relying heavily on our judiciary to provide and deliver the service. In terms of what we typically do, we do not have at this point, any mandatory mediation programs, and we're relying heavily on the information that we're gaining in this process from our Western brethren in terms of how they're choosing to deal with the increase in self-represented litigants. So for us, we're keenly interested to see what the other jurisdictions are doing. What we do here is we funnel most of our family law cases, which I'll talk primarily about, through our Family Conciliation Services. And that particular service is actually at arm's length from Manitoba Justice. There is actually under a separate department, our Family Services and Housing Department, which can create some issues from time to time in terms of dialogue between the two departments. But what we do here is we require, early on in the court process, that the parents attend a parent information program. That funnels them into a case management conference with a judge in Winnipeg. And at that point, the diversion occurs to our Family Conciliation Services, and there's typically a referral made to mediation. That referral is not mandatory, it is a voluntary, but our judges, especially in our Unified Family Court, are expert at persuading people that it's in their best interest to voluntarily attend mediation. And the mediation services are offered by our staff at Family Conciliation Services. We're also somewhat unique, because we like to be unique in Manitoba in many ways. Our Family Conciliation Office staff are often, who deliver the services, really have a dual function. They both serve as evaluators under our Court of Queen's Bench Rule 49. They're also providing mediation services under Section 47 of the Court of Queen's Bench Act. So they actually have a dual role. And within that dual role, they deliver certain types of services. Certainly they do the mediation on custody access and private guardianship matters. That service has been delivered for many years. I don't have the up-to-date statistics, but the feedback has been quite good in terms of the resolution of matters. They also have, when there's property matters, our co-mediation program, where we can deal with property matters. We have a very experienced family law lawyer who's probably been practicing for about 35 years. runs that program, and the results from that particular program are very good. What we do typically, if matters are more complicated or meritorious of evaluation, is that we'll use the first choice program, and that particular program will deliver services. And I've talked a bit about in the third slide, the first choice program, where there's a combination of evaluation, a little bit of mediation, and the involvement of potentially legal counsel to assist. That program is relatively new. When I was in private practice, it did not exist. It now exists, and the feedback I'm getting from people is it's viewed very positively. We are not as advanced in dealing with child protection matters. However, we do have a new pilot program that has been initiated by our Minister of Family Services, and we are now providing, in a test group of 10 particular files, child protection matters, the option of participating in mediation is more to do with the plan of care, not the need for protection, but the plan of care, which often is a stumbling block in the resolution of matters where the agencies are requesting either a supervision order or a temporary order of guardianship of a relatively short duration. Those are matters you typically do not want to go to a trial because of the long delay in getting to trial, and a lot of those issues can be resolved potentially through mediation. So that's a new program that's just been initiated in Manitoba. We do have mediation offered in several matters, but it's limited to our judicial assisted dispute resolution program, where, quite frankly, it is the most informal process one can imagine. All counsel are required to do is write a letter to the Chief Justice or the Associate Chief Justice asking for mediation. And it's a very informal process. In fact, there's been no groundswell to change it that I can detect at all in Manitoba, and the claim settlement rate is in the range of 85 to 95%. So perhaps less is more in terms of civil litigation in Manitoba, but they seem quite pleased with what they've put in place now. We do have now an option in small claims matters where a hearing officer will provide some mediation, but my initial check with our small claims people is that the only uptake on the offer of mediation is that immediately following a decision of a hearing officer, and it's usually the unsuccessful litigant all of a sudden wishes to pursue mediation. In those particular circumstances, unlikely the successful party is going to want to mediate after they've been successful in a protracted small claims matter. I have provided some information in terms of contact information that is on our Family Conciliation website. Again, that's different from our Justice website. And certainly available for any questions should anyone have any questions. But in Manitoba, at least, we prefer to keep things relatively simple. And at this point, we haven't looked at any type of a mandatory mediation program. However, my job here in Manitoba is to look at the advances of the other Western provinces, beg, borrow, or steal any good ideas I can get, and present them to our Deputy Minister in an effort to perhaps forecast in the future the ongoing needs of self-represented litigants to at least have an option available to them outside of our existing programs. And with that, I think I'll go back to Daryl. That's our next move.
Thank you. So I'm aware of time. I'm going to try and move through the next couple of slides fairly quickly because I think it's most important that you have an opportunity to ask questions. I think very quickly, there's a lot of similarities, a lot of differences between our programs. And again, this is really why we're sharing this information and we're collaborating. It can be problematic when there's significant differences in terms of different provincial government programs and how they're delivered, compensation practices, qualifications, everything. So, excuse me, the more that we can do to better align ourselves, in the long run, I think that's how we can contribute to advancing ADR, and ADR as being recognized as not only legitimate, but the preferred option for engaging the court system. And so really, one of the similarities for all of these programs is that they do help parties with alternative ways to getting resolution to their disputes rather than going through the formal court system. And I think we've probably heard a lot of that recently. So one of the ways that we're going to do this, and we have actually a guiding principle for continued collaboration, and that is, if you don't mind just going back to the previous slide, Patricia, thank you. So our goal and our guiding principle is to align with the goals of improved access to justice by developing systems that focus on citizen needs, that comprehensively transform conflict, and that provide increased access to processes that are timely, cost-effective, and proportionate to the issues. You know what? Even when I read this, I think, wow, there's a lot of big words in there. What does it really mean? Okay, so what we're doing going forward, we have agreed as the Western provinces to promote learning through increased and continuous communication between the Western provinces with regard to implementation of new programs, services, and changes to existing programs. So when we go down the road to look at implementing new programs, I'm going to look out to my colleagues in the other provinces, and they're going to do the same so that we can talk about it, we can learn from each other, we can implement programs based on the learned experiences from other areas. We're also looking at how we can better build triage into existing and new processes. And I'm sure this is something that was discussed for those, again, who attended the Reforming Family Justice Services portion, and probably many other discussions. This is a real hot topic right now when it comes to how do you get people involved in court-connected, specifically ADR programs. And so how can we build triage into existing processes that will promote the use of interventions appropriate for the specific conflict? And that's very important, appropriate to the conflict, and that support a proportionate degree of intervention to the issues. So triage should be decided, the panel believes that triage should be designed in a way that allows access to intervention processes, whether mandatory or voluntary, before citizens are required to engage the formal court system. Okay? And that's really the goal. We're looking at a cultural shift. We're also looking at promoting consensual dispute resolution in general and mediation in particular as a viable option to resolve conflict and an acceptable part of the justice system. This includes placing emphasis on increasing the legitimacy of consensual dispute resolution by ensuring that services are delivered by professionals with an acceptable minimum standard of training and qualifications. Right? I think this is very important too. If in Alberta here we don't have any qualification standards, it's going to be very difficult for our Western colleagues to promote a certain level of qualification standards for their programs. I think that if we're more unified across the board with these things, it'll be easier for us to justify the need for a certain level of, not just qualifications, but standards in general for our programs. And that's really what we're looking at. So, our next steps are continued cross-jurisdictional dialogue. We're always learning. Those summaries that you received today on the programs, I wish we had a lot more time. I can see on the faces it's Friday afternoon in here, and people are looking at their clocks, and that's fine. But really, there's a lot more information that we can gain from comparing programs and lessons learned. So if you do have questions and suggestions, I really hope that you can contact us. I see some hands. Further, we're looking at how we can define mandatory programs and must consider the proportionality.
My question is that we want having mediators that have these qualifications, these minimum standards, and getting those qualifications isn't inexpensive. Maintaining those qualifications is expensive.
Yes.
And being in private practice and keeping up on current things, the fees that we're paid for, considering what you're expecting of us, we're basically go get our education, get our training, keep it up, and yet our work is not seen as valid.
So I know that there's a lot of work being done right now to identify appropriate compensation standards and to make recommendations based on that. I can tell you that we do take this seriously. I can speak only from the Alberta perspective with this, but we do take it seriously, and I can tell you that we've made recommendation after recommendation to better align the compensation practices with what's expected. It's kind of a double-edged sword, because we're certainly not going to say that with this economic climate, unfortunately, compensation is what it is right now, and clearly it's not at the level that's expected. That's acknowledged. I think also, though, that we can't reduce the level of qualifications that are required because of that. So what do we do? And this is where really we are looking for suggestions. And sorry, I did see that there's other questions, but I just want to just quickly finish here. So we're looking at identifying qualifications that are consistent. We're looking at continuing to share program evaluation and establish similar methods for the measurement so that we can accurately track the return on investment of our programs. And that's actually what's important to your question as well, is if we can better identify the value that you bring to our programs when you're delivering these services, then we're better positioned to request that funding for an increase. Right? And unfortunately, we're not there yet. We're not at a point where we can easily say dollar for dollar, this is what it is compared to a court process. We're very close, but we do need to do more work. So there is a microphone here. I believe we still have a couple of minutes for questions. So if there is other questions, I saw a hand in the back. Thank you.
I noticed that a number of provinces have some element of mandatory mediation, either through the rules of the court, you're requiring it, or some rule, or judges strongly encouraging people to go to mandatory mediation. In Alberta, I know that mandatory mediation was tried in the Court of Queen's Bench, but it no longer exists there, as I understand it.
They suspended, that's correct.
Yeah. So that the rule is temporary suspended.
Okay, so we don't have it. My question is, from the different provincial people, is mandatory mediation an effective way to get people to have their issues resolved?
I love that question, and I'm going to turn it over to our panelists from other provinces to start.
Answer that one, Gina.
So Gina, Daryl, can you hear me okay?
Yes.
If my thinking is to the person who asked the question, that if we didn't have mandatory mediation, we wouldn't be having the uptake that we did, that we would have in any of our programs. So that's the first thought that I have. The second thought is, as mediation gains in popularity and as it gains more credibility and legitimacy, it becomes less of a question about whether it's mandatory or not. To me, it becomes more of a question of how effective are we at mediating, whether it's through a mandatory program, a legislative program, or a voluntary program. And as mediators, in my mind, that's what we need to be thinking about, is no matter what kind of program we're working in the private sector, in the public sector, if our focus is to create solid, credible mediation options, that's going to grow the industry even more. And I think from a perspective of abundance as opposed to scarcity, when I think about how we all can contribute to mediation becoming much more widely acceptable.
This question may relate to, or may show lack of faith in humanity. However, I guess it's kind of a two-part question. To pay mediators on an hourly basis, is there an ethical concern that they could stretch a mediation longer than it should? Number one, and number two, if that's the case, is there a way for you to pre-assess a mediation to this block of hours or time?
That's a very good question. And so I think that simply the answer could be yes, but we have to trust that our mediators who are qualified and have been admitted to our programs are following proper policy, and we have no reason to believe otherwise. We do monitor the length of time, and we do monitor the length of time compared to resolution and not resolution. And we do have set standards for many programs. So many of the other provincial programs, similar to Alberta, have a maximum amount of time that would be covered by the government in order for those services to be provided. I'd also like to note that not all programs are paid by the hour, right? Some programs are paid by the session. Particularly in Alberta, our civil claims mediation program, the payment is by session. That's different from family mediation, where our contracted members are paid $80 an hour, up to 9 hours, and that does include report time and administration. So I think we can also question what's the appropriate length of time. that should be compensated for mediations. There's all kinds of ways that we can look at this, and again, that's why I'm going to refer back to our panel here, and I'm just going to say that that's why we're learning. We're trying to learn from each other and see what others have done and how we can implement it in our own areas as well.
May I just add to that, as a mediator on that roster, trust me, you do way more hours than even comes close to what you're paid for.
Yes.
It's just, and then we do it out of our heart. No, and it's not, but I know it's just because, you know, people say, oh, external. Honestly, you, as most mediators, I believe, you go beyond that just because your interest is there to help that family, so.
So I want to comment and offer a suggestion as well. So first of all, thank you for doing all of this. It's great that all of the Western provinces got together and there will be a foundation upon which we can learn and trade ideas, and hopefully the families and generally conflict will de-escalate and families will benefit from that. Here's my suggestion. We are talking about getting people into the programs, and discussion has been ongoing whether it should be mandatory or not mandatory. What about if we went back in time and listened to somebody called Lincoln, and he said at one point, discourage litigation. Okay, so when I was in Australia 2 years ago, what they did was they increased the filing fees in the courts. So what if, instead of paying a measly 100, 200, whatever it is nowadays, what if for somebody to start an action in court, they had to pay $1,000 or $700? Don't you think they will look somewhere else to resolve their dispute?
Ideally, in a perfect world, I would say simply yes. I think the reality is that as you increase the court fees, you also have questions about access to justice and how attainable those services are. Thank you, and we've been told several times by our hosts here that we're over time, and you know, I'm sure there's tons of people who have great questions. So.
I don't see Jim here in the room to thank you, but on behalf of ADR Canada and all the folks that were able to attend this session today, I'd like to thank all 5 of you for being present either virtually or in person, and I think it's been very informative. So please join me in thanking our speakers.
So one final thought is that really, I mean, you'll have all of our contact information accessible. Please feel free to contact any of the panel members if you have questions specific to programs, or if you have recommendations for how we can work together as the Western provinces. That's really what we hope. That's the big message, is we want to advance ADR, but we can't do this without the ADR community as well. So please send us your feedback.